the notice up to the end, right? And thereafter you will interpret.
Thank you.
Just as a matter of procedure, okay, fine. So the legal aid board signed, in essence, on behalf of your client. Because an advocate, as I understand the law, when you make an affidavit on behalf of your client,
Yes.
the instructing attorney has got to sign. Now, I see here, obviously, your instructing principal is the legal aid board.
Yes.
Okay, fine. Okay. Yeah, you can go ahead.
Let me just explain that.
Yeah.
Yes. The court will see there that this is dated the 17th day of April 2025, which was on a Thursday.
Right?
Yes.
Okay, fine.
At the time at which I completed this affidavit, I could not go to the offices of the legal aid because it was already late.
Okay.
So I signed on their behalf, but I indicated that the proxy because this is something that I discussed with them.
Okay.
I had a meeting with them on a Wednesday that took almost half a day.
Okay, fine.
As a previous court member.
Right.
Now, this is a notice of motion, which simply says that kindly take notice that an application will be moved on behalf of accused number 1 to the above honorable court for an order in the following terms. Number 1, that his legal representative be granted a further postponement to continue and finalize his preparation in the matter. Number 2, further and alternative relief. Now, this is the founding affidavit that has been prepared by me. Now, paragraph 1, I'm an adult male, a practicing advocate in good standing with the Legal Practice Council, and I represent number 1 and number 3 in this matter. Unfortunately, the pages are not numbered. I'll go paragraph by paragraph. Number 2, the facts that are deposed to herein, save where the contrary appears from the contents, are within my personal knowledge and are to the best of my knowledge both true and correct. Now, the purpose of the affidavit. The purpose of the affidavit is to implore the court to allow the above-mentioned matter to be postponed to a further date on the 22nd of April 2025 to allow me time to finalize my preparations for the commencement and presentation of the case on behalf of accused number 1. The factual background. That's paragraph 5. I've been part of the case representing accused number 3 since inception before the Honorable Mokgwatleng J. After the passing of Mr. Ngomezulu, who was representing accused number 1, I was approached by the Office of Legal Aid South Africa with the request to take over and continue to represent accused number 1. I duly accepted the request and I formally came on record as accused number 1's legal representative on the 8th of January 2025. A provisional date on which the legal representation of accused number 1 is to be confirmed. Paragraph 6. The matter was then postponed to the 20th of January 2025, which was the original date arranged for the continuation of the matter on merits. This time, the witness who is currently in the witness stand was being cross-examined on behalf of accused number 5. That cross-examination was concluded on the 22nd of January 2025. The matter was then postponed to the 10th of February 2025 to give me time to prepare, and this time the state confirmed by indicating that the record of the evidence stands around 40,000 pages. Paragraph 7. On the 10th of February 2025, the matter was before court again, and I made an application for a further postponement as I was not yet done with my preparations, and the application was granted. The matter was then postponed to 14 April 2025, and I made an undertaking that I will be ready to proceed on this date. It is unfortunate that I was still not yet done with my preparation and that thus not yet ready to proceed with the matter on this date either. The events of the 14th of April 2025. That's paragraph number 8. I arrived at court on this date and immediately conscientized all my colleagues, that's the state and the defense, that I was not yet ready to proceed as my preparations for the matter are still ongoing, and I requested that we approach the Honorable Judge in chambers on this issue. In the Honorable Judge's chambers, at the introduction of my inability to proceed with the matter due to the fact that I was not yet done with my preparations, the Honorable Judge directed that I should put that information on record in court. Paragraph 9. When the matter was then called and the preliminary issues dealt with by the state, the court then invited me to address him on my application. I submitted that I had underestimated the amount of work I had to cover between 10 February and 14 April 2025 when I indicated that I would be ready by this day to proceed with the matter. And due to the fact that I am not yet done with my preparations, I was not in a position to proceed. Immediately after those introductory submissions, the court took over and dealt with the application, although I was not yet finished with my submissions. Paragraph 10. I never got to ventilate the issues which constituted the challenges in my preparations. Neither did I got to indicate how much field did I already cover and how much is still left. I also could not indicate how much time were I requesting to finalize my outstanding preparations. When the court, after having heard submissions from the state and remarked that I was abusing the process or system, and I never came across an experienced advocate as myself who was unable to read and complete 40,000 pages in 2 months, he went on to suggest the date of the 22nd of April 2025. It was at this point that I stood up and requested indulgence and told the court that I would still not yet be ready by this date, and if the court were to insist that a matter should be proceeded with, despite the fact that I would not have completed my preparations, I'm going to request to be excused from representing accused number 1. Paragraph 11. The final decision was that the matter will have to be proceeded with on the 22nd of April 2025, and that accused number 1 will have to intercede in the circumstances if I would still not be prepared. Paragraph number 12. The cause of my preparation of the matter does not only involve reading, it also involves analysis, constructing and comparing, formulation of issues and arguments, research of applicable and relevant authorities from the legal literature. The list is exhaustive. Paragraph 13. Furthermore, the cause of my preparation in reading the record is also characterized by the fact that the record itself keeps on referring to other parts of the records which would have been previously dealt with, and to refresh my memory and to confirm those parts of the evidence being referred to, I am compelled to go back to those parts of the evidence on record being referred to. Paragraph 14. Similarly, the record will refer to some exhibits which would have been dealt with in other parts of the record, and again to confirm and to refresh my memory on those aspects being referred to, I am compelled to have regard and revisit those exhibits being referred to. For instance, I am reading the proceedings of the 24th of October 2024, and the evidence referred to as an exhibit on the proceedings of the 23rd of January 2024. I would have to go and revisit that aspect of the evidence. These are some of the aspects which make my preparations tedious. Paragraph number 15. Having spent 2 days at Morabi Correctional Facility consulting with Mr. Sibiya, a number of issues came up which necessitate further follow-ups which do not form part of the record of the transcripts, and thus the preparations are not necessarily limited to the record. The suggested period of 2 months within which I was expected to finalize my preparations does not factor in these extraterrestrial issues. Paragraph number 16. It also emerged from the consultation that we'll have to request further information from the state, which is central to accused number 1's case, and to my preparations, even before I can start to cross-examine the current state witness. These are all the aspects which I intended to bring to the attention of the court had I been afforded the opportunity to do so. Paragraph number 17. When the state was requested to respond to my incomplete application, it rationalized the importance of a further postponement, taking into account the nature of the preparations that I needed to do and acceded to the reasonableness of such an application. The state cannot be faulted on anything it said in its response in this regard. Paragraph number 18. It also emerged during my preparations that I was not in possession of all the transcript of all the proceedings in the matter. I requested on an occasion or two assistances from the former court's registrar for assistance with those transcripts. I managed to get some and some not yet. As I'm preparing this application, I still do not have the records of the proceedings for the year 2025, without which my preparations would still not have been complete. The last communication that I received from the current registrar in respect of the records of the transcript was on the 21st of January 2025, and these were the transcripts up and until the last term of 2024. Paragraph number 19. I am very mindful of the fact that justice delayed is justice denied, and this applies mutatis mutandis. I would therefore not have embarked on a scheme to willfully delay the proceedings or hold them at ransom. I am perfectly aware that the accused are going through agonizing time with the trial hanging over their heads like a sword. They are keen to know their fate in the matter. The same principle goes to the family members of the deceased and all the people who take interest in the matter. I can, however, assure that there is not even the minutest iota of malice in the manner in which I am trying to conduct this case on behalf of Mr. Sibuya. Paragraph number 20. In criminal proceedings, any suspicion of delay or any suspicions of delays are regulated by Section 342A of the Criminal Procedure Act number 51 of 1977. These provisions prescribe the manner in which such delays should be investigated, what constitutes delay, and its effect on the stakeholders in the trial and the mechanism of dealing with such delays. Paragraph number 21. While trying everything that I possibly can, I am and should always be mindful of the fact that the accused is entitled to a fair trial, which includes, inter alia, a right to legal representation. I am thus willing to proceed to assist the accused in the conduct of this case. This should, however, be understood in the context that a proper preparation is a cornerstone of the realization of that right to legal representation. Number 22. That's paragraph 22. On the 25th of April 2025, at 16 hours 15, that is 4:15 in the afternoon, the state sent me an email with a set of photos with the following message. We, open quote, we have extracted the attached photos from the phone downloads to be used as evidence, close quotes. Above the preparations that are already ongoing, although not yet finalized, this aspect of the new evidence should also be factored in the preparations and be considered in the totality of the whole body of evidence led thus far to formulate a challenge to it, if there is any. Excuse me, my lord. I think there's something that the interpreter wants to bring to my attention.
Pardon, my lord, at the date, 25th of April.
25 April.
Has it jumped that sentence?
Yes, my lord.
Yeah, because I read this motion.
Trying to bring to him.
Yeah, fine. I'm aware
Yeah,
of
I
it.
think it should be March. Yes. I'm sorry. On paragraph number 22, corrections. Paragraph 22, the date should read on 25 March 2025 at 16 hours 15. The state sent me an email with a set of photos with the following message. Open quote, we have extracted the attached photos from the phone downloads to be used as evidence, close quotes. Over and above the preparations that are already ongoing, although not yet finalized, this aspect of the new evidence should also be factored in the preparations and be considered in the totality of the body of evidence led thus far to formulate the challenge to it. These new developments further compounds and consternate the preparations in the matter. Paragraph 23. Although I have been part of the matter since its inception and has been following the trajectory of the evidence, that does not translate to the fact that I know each and every little aspect of the case and the evidence which has been led thus far against accused number 1. I have never consulted with him before. I've never received any instructions from him before, and never have I given him any legal advice before. In fact, I started to realize that there's so much that I did not follow in his case, not this, but in his case, when I am preparing this matter as his new legal representative. Paragraph number 24. It is very difficult as a legal practitioner to represent an accused who's facing a potential life imprisonment on the basis of the charge or the charges that he is facing, to prepare the defense of his case with the feeling that a gun is being held over your head and are expected to do things out of the ordinary. This takes away the creativity, spontaneity, and the art of independent thinking in the conduct of his case, and this does not resonate with the right to a fair trial. Paragraph number 25. In the circumstances, I respectfully submit that any form of pressure exerted on me to be prepared to proceed with the matter on the 22nd of April 2025 will not yield the desired results of affording the accused a fair and dignified trial as required by the Constitution of the land. As I indicated before, I could have underestimated the amount of work that I had to go through in the preparation of accused number 1's case. I respectfully submit that if this is to be held against me, it was inadvertent and without any malicious intent. Wherefore, I humbly pray that my request for extension of the time for the preparation of the matter on behalf of Mr. Sibia be granted as per the notice of motion, dated the 17th of March, 17th day of April 2025. It was signed by me. Thank you.
Ummeli omeleke umsola oqala ke umnumzana uSibiya kade alethe inkulumo yakhe la ngaphambi kwenkantolo mayelana nesicelo sakhe ke lesasenzile ke athi yena ke ubhalele incwadi ebhala ke inkosi yenkantolo mayelana nesicelo sakhe uthi inkosi yenkantolo imuphe ke isikhathi esanele ethizeni ke enze amalungiselelo akhe mayelana nokuhlela icala leli lokumela ke umsola oqala kule cala abukane nalo ngaphambi kwenkantolo ke la paragraph oqala yasho ukuthi yena ke umuntu osilisa omdala ke osebenza ngapha okummeli futhi osebenza ngaphansi kwe-legal practice council futhi yasho ukuthi umele kumsola oqala futhi umsola wesithathu kulecala leli ke futhi yasho ukuthi konke okubhaliwe ngalana ke ubhale ngoba yena kade akwazi futhi ubhale ngaphansi kolwazi lakhe futhi konke okubhaliwe kuyiqiniso nje kuphela futhi yasho khona njalo le affidavit lena ke uhlelo lakho ukuthi akubhaleke kuyinhloso ukuthi ke becela ukuthi malana nelanga leli kalicilile isikhathi esanele sokuthi enze amalungiselelo akhe manje icala leli ke ethi ngelanga lange 22 zaka April kumnyaka esukubona ke lingaqhubiki futhi cathi mhlawumbe uyobe sekakulungela thizeni ke amele ke umsola wokuqala ngalanga phambi kwenkasenkantolo malana nodaba lwecala lelike uyasho ukuthi wena njalo kade ayingxenye ecala lelike kepha ngesikhathi bekayingxenye kule cala bekakade ameleke umsola wesithathu kule cala lelike ngaphambi kwenkasenkantolo ekhona ke la umkhwahleni ekhona ke la inkantolo ke futhi kwaphoqeka ukuthi na ke amele umsola wakhe wokuqala ngemuva ukuthi kushone ke ummeli kamsola wokuqala ke umnumzana ke uMngomezulu ke futhi asho ukuthi lapho kwacelwa ke abe office lapha kwa legal aid lana kiningizimu ethizeni ke aqhubeke necala leli amele komsola wokuqala futhi asho ukuthi nakhona lokho wavuma ngoba kade ke ebona ukuthi kuyinto elungele ethizeni ke amele komsola wokuqala futhi lokho kwavuma ngelanga la nge-8 zaka January kulomnyaka losuku wona ke futhi waqala ke date ethizeni wona komsola ukuvuma lokho bese babuya futhi enkantolo ngelanga la nge-20 zaka January kulomnyaka 2025 ethizeni bathole ke uqhubeka necala leli ke ngesikhathi lesikade kukhona ke ufakazi kakhona la ngaphambi kwesenkantolo ethula ufakazi bakhe ngaphansi kwesifungo ke ufakazi loyo ke ngesikhathi ke bambuza imibuzo emelana nomsola wesi-5 ke lapho ke futhi yasuthi ngelanga la nge-22 zaka January kunyaka 2025 icala leli ke balimisa bahlehlisa ilanga la nge-10 zaka February kunyaka 2025 ethizeni athole ke isikhathi esanele ethizeni ke akhulumisane ethizeni athole ke imibukiso futhi imibukiso ekhona kade khona ke la ngaphambi kwenkantolo ke basho ukuthi amakhasi awu-40,000 kwamanje ekwakumele ukuthi abafunde kade enofakazi ke amakhasi wonke ke lawo ke uthi kumele ukuthi afunde ufakazi lokho okubhaliwe kulo makhasi wonke ke lawo ke ethizeni alungisele icala leli-ke futhi wabuya ke ngelanga la nge-10 wenza ke isicelo sakhe sokuthizeni ke inkosi enkantolo imuphe isikhathi esanele sekuthizeni bahlehlise icala leli bahlelisele ilanga la nge-14 zaka April kunyaka 2025 lokho ke wakwenza ngoba kade ecaba ukuthi mhlambe nakhe uyobe sakufundile konke kokubhaliwe noma konke lokho kade kushicilelwa la ngaphandle kwesenkantolo kepha uyasho khona ukuthi lokho akaze kube isikhathi esanele ethizeni ke ayilungisele noma ayihlelele icala leli la kamsola wokuqala abukane nalo futhi aqhubeka uyasho khona ukuthi ngelanga la nge-14 zaka April kunyaka 2025 khona lapho ke uqhamkile ngaphambi kwesenkantolo ngesikhathi befika la enkantolo wacela ke laba sebenza nabo ke ozakwabo ethizeni bahambe bayilapha phezulu bakhulumisana nenkosi enkantolo ayitshele khona njalo kuma-ofisi wakhe ukuthi akakulungele yini noma kade angakulungele ethizeni aqhubeke necala ngalelanga lelo-ke ngoba kade kunezinto bafisa ukuthi athande ayiqedele malana nomsola wokuqala uyasho khona njalo ukuthi khona-ke lapho-ke malana nodaba kade lukhona-ke lana-ke nake uludingidile udaba lolo-ke futhi nohlangothi lwezombuso-ke lapho-ke ngesikhathi kade senza lokhu-ke nacathi mhlawumbe isikhathi lesi bekasicelile ngelanga la nge-10 zaka April kuze kufike-ke ngelanga la nge-14 zomnyaka ka-April kunyaka 2025 bekuzobe isikhathi esanele sekuthizeni afunde konke lokhu kade kushicilelwa la ngaphambi kwenkantolo mayelana necala leli bese-ke enze-ke iy'nhlelo zakhe zokuthi abe sekalungele ukuhlala phansi necala leli bese sesaqhubeka emela-ke umsola kepha lokho eyasho khona nje ukuthi kade kungasona-ke isikhathi esanele leso-ke kepha naye kade angakwenzi ko ngoba kade kathanda kepha-ke ungaphansi kwengcindezelo yokuthi-ke amakhasi awu-40,000 bekumele ukuthi awafundeke uma ecaphula esho khona ukuthi la makhasi lana-ke kunofakazi lakho obukhona-ke mhlawumbe athi uma afunda khona njalo ufakazi bakhona bengelanga lelo-ke ukuthi mhlawumbe kumele ukuthi aphinde futhi ahlehle abuyele emuva-ke ayobuyisela umcabango wakhe mayelana nofakazi kade bethulwe ngaphambi kwesenkantolo uma sekabuka kula makhasi ngoba amakhasi awabhaliwe ngenombolo eyiqondile esalana emuva ngendlela eqondile uyaqhubeka uyasho khona njalo ukuthi isinqumo lesi asicelile-ke ngelanga la nge-22 kuthizeni-ke icala bahlehisele ilanga la nge-22 ngomnyaka April ngenyanga ka-April ngomnyaka 2025 ukuthi aqhubeke amele-ke umsola wokuqala noma alethe ufakazi bakamsola wokuqala noma mhlawumbe athule kufazi bakamsola wokuqala kade ngasona-ke isikhathi esanele leso-ke mayelana nodaba lolu-ke uma aqhubeka futhi ngenkulumo yakhe uyasho khona njalo ukuthi uma ebuka-ke imibukiso yona ekhona lana-ke noma ngesikhathi bekabuka-ke ushicilelo kade lukhona-ke la ngaphambi kwesenkantolo yokade alifunda khona njalo-ke kunokunye lacaphule khona-ke washo ukuthi ngesikhathi bekafunda-ke mayelana nohlelo noma mhlawumbe ney'nhlelo zala inkantolo kade zihleli ngelanga la nge-24 zaka-October ngomnyaka 2024 bekumele ukuthi futhi aphinde ahlehlele emuva kusemcabango wakhe ayahamba eyobuka-ke kufakazi okade kulethiwe ngelanga la nge-23 zaka-January ngonyaka 2024 ngoba bekungahambi indlela eqondile noma bengasalani emuva indlela eqondile futhi yasho wachitha-ke amalanga amabili-ke elapha-ke kulela jele lalapha-ke Motor B Correctional Facilities lapho ngesikhathi kade nenkulumo-ke ekhulumisana khona-ke nomnumzana kosibiya okade kumsola-ke lapho-ke lecala leli okumsola vele kule cala leli-ke uyasho lapho-ke ngesikhathi kade ekhulumisana naye kwaqhamuka-ke iy'nhlelo mhlawumbe izinto eziningi lapho bemelwe na futhi ahambe ayobuka futhi amarekhodi noma usicelo la inkantolo ekuthizini lokho kumuphi isikhathi esanele ukuthizini ashesheke aqedele ukuyilungisela mayelana necala leli ke futhi yasho ukuthi ngemuva kwalokho ke wacela bacabanga ukuthi mhlawumbe isikhathi siyinyanga ezimbili ke lapho ke bekuzoba isikhathi esanele ekuthizeni ke asheshe akhona ukuqeda lokho ke kepha ngomcabango wakhe lokho akumsebenzelanga kahle ngendlela eqondile futhi aqhubeka washo khona ukuthi nakukhulumisene nawe ke futhi ngemuva kokukhulumisana nawe isikhathi eziningi futhi ukukhuluma nombuzo mhlawumbe lezombuso ke lapho ke ngesikhathi ekhulumisana nabo ke wabona ukuthi lapho ke kunezinto futhi ezingakhona ke ezingekho ke lapho ke futhi angeke ukhona ukuthi wona aqhubeke nofakazi wakho mhlawumbe aqhubeke necala lakho ke alithulela ngaphambi ngesenkantolo ke waqhubeka futhi washo ukuthi ngesikhathi kusenzeka konke lokhu ke khona lapho ke kunezinto eziqhamukhile ngesikhathi ngesenzeka amalungiselelo akhe ke ukuthi bekanganawo amanye ke amakhasi ekuthizeni ke kwamele ukuthi afunde kuona ke ngoba lokho wacela ke hlangothi lezombuso ukuthi lumuphi isikhathi bamuphe ke uhlelo lokho lolo kade beshicelele kade yena ke nalo nakhe ekuthizeni ke ahlale phansi bese ke alifunde ke imibukiselo yeke futhi abuke ke afunde ngamakhasi futhi alalele futhi nalokho kade shicelo la ngaphambi kwesenkantolo bese kuthi nalokho wakuthola ke amakhasi ogcina ke ngelanga la nge-21 ngenyanga kaJanuwari ngomnyaka ka-2025 lokho kade kufakazi kade sokutholakala ngaphambi kwesenkantolo uqhamuka kumnyaka ophelile kuzefika ngelanga la nge-21 kaJanuwari uyasho khona njalo ukuthi lapho uyacela ke khona njalo ukuthi lapho kuyasho ukuthi ubulungiswa ulungiswa kumele ukuthi bebe khona ke lecala leli kepha ke khona lapho ngesikhathi senza lokho uyasho ukuthi lokho kuyafana ukuthi nake usheshe uyashesha egijimiseni icala leli noma mhlawumbe kufanele ukuthi nake kuyofana nokuthi ke lapho sebathathe umkhondo babeka komkhondo phezu kwekhanda lakho wona ke mnumzane Sibiya uyasho ukuthi futhi wacaphula khona njalo ngaphansi kwezomthetho lapho ku section 342A lapho washo khona njalo malana nesigaba saka 51 of 1977 ngesikhathi bekafunda ke futhi asho khona njalo ukuthi ubulungiswa obuze kade kepha kusibulungiswa obungafikile lapho ke futhi waqhubeka washo khona njalo ngemalana nesicelo sakhe ke washo ukuthi uyazi futhi ukuthi lokhu bekumele ukuthi akwenzile futhi nawe nakumsola futhi unelungelo ukuthi ke icala kohlalwe phansi ngendlela ekahle futhi bahlele kahle futhi lihlelwe kahle ke futhi lihlalwe phansi ngendlela eqondile futhi nangendlela ke ilungile lapho ke ekuthizeni bekhona kubulungiswa ngaphansi kwecala lakho ke waqhubeka washo futhi khona njalo ukuthi lapho ke yelanga la nge-25 ngenyanga kaMashi ngomnyaka 2025 isikhathi ngemuva kwehora laka-4 ntambama ke lapho ngemizuzu o-15 ngemuva kwehora laka-4 ntambama ke wathola ke nakhe i-email noma umbhalo kade uqhamuka ke lapho kuhlangothi lwezombuso ke kade lunezithombe ke khona lapho ke khona njalo ke laba bhale khona besacapula khona njalo bathi bazithulile ke ithombe lezi ke kade qhamuka ke kumakhalekhukhwini noma ocingweni yizo kade bedownloadile ke njengofakazi kade kukhona ke lapho ke futhi aqhubeka washo khona njalo ukuthi lokhu ukuthi ke ihlelo noma icala leli kade kuyinto kade enzeka ukuthi yena kade akhona ngesikhathi icala beliqala kuhlala ngaphambi kwesenkantolo ngaphambi kwesenkantolo ekhona ke lapho ke futhi ufakazi okhona lapho futhi uyabazi ke kepha noma ufakazi okhona lapho akabazi ke futhi akaza akhulumisane nawe ke noma atshele kohlangothi ukuthi ukuthi yena ke uzizwa njani icala leli ngoba lapho bekangamele wena la ngaphambi kwesenkantolo kepha bekamele umsolo wesithathu ke lapho ke futhi yacela ukuthi lapho kathole isikhathi esanele sokuthi enze amalungiselelo akhe ekuthizeni ke akhone ukukumela kahle kule cala leli ubukene nalo ngaphambi kwesenkantolo.
Thanks. Way through. Yes, Mr. Maloi, what new evidence is that? You say in that affidavit that there are photographs which you apparently handed over to Mr. Mnisi on the 25th. What is
that? My Lord, the correct date is the 10th of April.
The 10th of April?
Yes, 10th of April we sent an email to all counsel to alert them of the fact that there are certain photos that we intend to use, and these photos pertain to accused number 3 as well as accused number 2. They don't pertain to accused number 1 at all.
Fine. So they also pertain to accused number 1 in essence?
Yes.
Also?
Yes. And these form part of the downloads to which counsel have access. The copy of the CD has been provided to all counsel.
Okay. Okay, fine. Yeah, all right. Mr. Ramsipidi, any comments, observations?
Suffice to say that.
Hello? Yeah.
Suffice to say, my lord, that I understand that requesting a postponement is an indulgence to the court, and that the court has got a discretion whether or not to grant that discretion. So a postponement is not there simply for the asking. It's not an apple that I want that apple, I pick it up. You come with cogent reasons to the court and fortify your case why a postponement should be granted, my lord.
Okay.
In the interest of justice, my lord, as long as there's no mala fides on the part of the applicant and justifiable reasons are given by the applicant, the court, in exercising its discretion in the interest of justice, should be inclined to grant that postponement, my lord.
Okay.
That is all that I'll submit for now at the moment.
Yeah, okay. Mr. Ngoman.
I have no comment except to say that my colleague's affidavit, it speaks for itself.
Okay.
Thank you.
Thanks. Accused number 1. Do you still want Mr. Mnisi to be your representative in these proceedings?
Yes, my lord.
Okay, fine. All right. I'll just deliver a short judgment concerning the exigency why this court made the order it did. Yeah, just a few remarks before. When this matter started, I was lectured by the advocates here that, our clients are being charged with a common purpose. And as a result, we were going to seek an indulgence to cross-examine any other witness who gives evidence, even if it's not directly implicating our clients at that time. Am I correct, sir? Hello? Yeah, and it makes sense because common purpose presupposes that what is done criminally or liably against accused number 1 is assumed to be done by accused number 2, 3, 4, 5. Is that not so? That's the definition of common purpose. So it's a reasonable request. Fine. This court is aware of Section 35F of the Constitution, that in terms of our common law, or rather the common law regarding postponements, regarding orders which are issued by the court, are predicated also on Section 35 of the Constitution. I see Mr. Mnisi quotes Section 342A, so that the public shouldn't get the assumption that this court, when it asks those questions, I wasn't asking those questions about when are you going to finish, when do you think you'll finish. I was actually conducting an inquiry in terms of Section 342A. Let's just read it, because I'm dealing with senior advocates. I'm not dealing with article clerks. Unreasonable delays in trials. This is Section 342A1. A court before which criminal proceedings are pending shall investigate any delay in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal representative, or the state, or a witness. And subsection 2 says, in considering the question whether any delay is unreasonable, the court shall consider the following factors. A, the duration of the delay, the reasons advanced for the delay, whether there is any person who can be blamed for the delay, the effect of the delay on the personal circumstances of the accused and the witnesses. the seriousness, extent, or complexity of the charge or charges. Okay, there are other reasons. I think that's sufficient. So this court, when I was inquiring from Mr. Mnisi, when do you think you will be ready? I was actually applying 342A. I may not have been explicit, like when you are lecturing, there was one student who said, now the court is going to inquire in terms of section 342A. What is causing the delay? No, because it's patent. I was inquiring. Okay. So, but Mr. Mnisi can't blame this court to say, I never gave him an opportunity to address the court. I gave you all the ample opportunity. And you know what was your last answer on the 22nd of April, is it? When I said to you, okay, tell me, when do you think you'll be ready? Your answer was, I will let you know. This is how some of the advocates address judges. I will let you know. That's what Mr. Mnisi said. We all know that you can't postpone a criminal trial indefinitely. A criminal trial has to have definitive dates on which it is going to be heard. Unlike a civil matter where you say the matter is postponed sine die. No, in the criminal trial, you can't postpone a matter indefinitely in a criminal trial. It's got to be succinctly stated that the case is postponed to such and such a date. Okay, I've said it. Nobody can accuse me of being unreasonable. Nobody. Even today, I'm prepared to ask Mr. Mnisi, when do you think you'll be ready? That's all. Say, are you prepared to tell me? When do you think you'll be ready?
Yes, my lord.
When?
I would request an indulgence, my lord.
When do you think you will be ready? The indulgence is about you being not ready, as I take it.
Yes, my lord.
So when do you think you'll be ready?
Around the 19th of May, you can come back. And the reason why I'm saying this, my lord, it's because the field that I've already traveled, it's more greater than the field that I yet have to travel.
So on the 19th of May, what's going to happen? You're going to report about the extent of the field you've traversed concerning your preparations.
Another point, my lord, before I answer that question is, as I've indicated in my notice of motion, there is information that we are going to request from the state.
What information is that?
I yet have to discuss with the state on the basis of what information is it. So depending on the time frame with which I get that information, me being able to go through that information, those are some of the factors that should also be factored in, my lord, on my state of readiness to proceed on the 19th.
You know what? Tell you, I've done criminal law for 50 years.
Yes.
Okay. This witness, Colonel Ginanda, has given evidence.
Yes, my lord.
And whatever documents Mr. Baloyi or Mr. wanted to present to Colonel
To Brigadier Gininda.
to Brigadier Gininda, or Colonel Gininda rather,
Yes.
it has been placed in court. The only aspect for accused number one through you is to cross-examine accused number one. I can't imagine new information coming, because that is the case which has been presented by the state, and that is the evidence which the state has presented through this witness. So whatever you need should have been.
That is the reason why, my lord, I said that in my affidavit, that subsequent to my consultation with Mr. Sibiya, it emerged that there is information that we will still request from the state to go through and prepare ourselves to cross-examine Mr. Gininda therewith or therefrom. it does not necessarily mean that our cross-examination will only be limited to the evidence that the state has presented, Madam.
Okay.
Thank you.
Have you requested that information?
Not as yet, my lord. I
When
have-
do you intend requesting it?
I can request it immediately hereafter, madam.
That's it.
However,
Okay,
the
fine.
reason why I could not request it before is because of the hurdle that we're busy with now.
Fine. Okay, fine. I hear you.
Thank you, my lord.
Okay, fine. This application is obviously not being opposed. As you said, you abide by whatever decision.
Indeed,
According
my
to
lord.
Mr. Mnisi, he's still going to request further evidence, documentary evidence from the state, as it says. Okay, you know what, I was researching this issue. The latest case in the SCA concerning Section 35, the rights to a fair trial, the rights to accord an accused person the opportunity of defending himself, which includes even cross-examining the witnesses which have been forwarded before this court by the state. And this case, I think it affects our case, although the facts are different. I read this case last week Wednesday. And basically this case, the judge in that, maybe you can take notice of this, is just Diffue, D-U-F-F-U-E. Here, a regional court magistrate in a rape trial which involved a minor was commenced before his court. There were 3 accused persons, including a minor accused. The allegation was that these 3 accused had raped the complainant. This case proceeded for a considerable length of time, and this poor child was taken through cross-examination because these gentlemen, the accused, were defended. Up to a stage where this child apparently got so overwhelmed and the trauma which apparently he has sustained, and it's not me saying that, it's the record, forced this child to just vanish from the face of this earth. Went away. They don't know where he went to. The investigating officer tried to look for this child. The child was not to be found. And consequently, because the cross-examination of this child was not finalized in terms of this child, but the 2 other accused, they cross-examined to the satisfaction of their attorneys and advocates, but the minor child, when she had to be cross-examined on behalf of the 3rd accused, as I say, she absconded from court and got lost. Subsequently, it was discovered that this child had actually committed suicide because she couldn't cope with the pressure of this case. So the magistrate, the learned magistrate, and the prosecutor and the defense agreed that the magistrate should close the case. In terms of the Criminal Procedure Act, a magistrate or a judge can close an accused case depending on the circumstances. And they decided that the issues pertaining to this matter have been aired. So if this minor child, she is now killed herself, the state and the defense agreed to close that case of the state. And these youngsters, three of them, two was a minor, one was a minor, they were sentenced to life imprisonment. And then this case was taken on appeal, and it went to the SCA. And Judge Defoe's finding was that in terms of Section 35, an accused person is entitled to defend himself against any crime which he's accused of, and his attorney or himself or his advocate is also entitled to cross-examine the state's evidence, including the evidence of this minor child. And as a result of the fact that that was not done, this learned judge decided to set aside that decision. And those youngsters, three of them, they walked scot-free. There was DNA evidence, they all considered that evidence, and they decided, like Mr. Baloyi perhaps would have, to say, well, there's forensic evidence, there's a J88, blah, blah, the state has proven its case. But just because of that lack of cross-examination concerning number 3, in respect of this alleged rape, the SCA set aside that. So amongst the reasons why I'm also going to accede to a further postponement is because of that case, the latest case. And I've also referred, I won't read it, I can refer to the case of S versus Chabedi, 2004, 1 SACR 477, Witwatersrand Division. This case was an appeal case before Van Oosten in Joburg, Maleka and Selvin. You can read it. So I'm amenable to a postponement concerning the law, as I've quoted it. But Mr. Mnisi must tell us, when are you going to be ready? That's all. I wouldn't know. When will you be ready?
May I request a short adjournment, Madam, so I have a discussion with my colleague
Okay,
for the
fine.
state as well. Thank you.
How long?
I think plus minus 15 minutes.
15 minutes.
Yes,
30
plus
minutes.
minus 30 will be fine.
Okay, 30 minutes.
Siphakame.
We'll be proceeding.
But proceeding.
Yes.
Okay.
There is, however, a suggestion that I should come on the 5th of May.
The 5th?
Yeah, on the 5th of May, just to come and indicate to the court how far am I, my lord.
So you want us to postpone to the 5th of May, in other words? Or you want to tell me, remember, I've just come here when the JP calls me for a matter. Otherwise, I'm retired.
Yes, my lord.
The other judges can come here Monday to Monday. Me, I only come for this case. But I do other matters. If the JP, for instance, or the deputy judge president says I must do appeals, bail appeals and da. But
We
if
can
you want me to
postpone it to the
postpone
5th.
9th, if you want me to postpone this matter,
Yes,
so for you to report to me
yes.
and the others that you are ready, I can postpone it to the 9th of May for that exigence. Fine.
It's fine, my lord.
Okay.
It's fine, yes.
Does it suit you, Mr. Ngumalo? The 9th of May.
I'm just checking, my lord.
What are you checking? Because this
The
case is
9th.
supposed to.
The
It's
9th.
not finished.
Maybe it's a
Hello?
Saturday. I'm checking
Saturday.
whether it's not a Saturday, the 9th.
So I must come on a Saturday here.
I'm checking that, my lord, whether is it not a Saturday. Or it's a Friday. The date is suitable. The 9th is a Friday.
Friday.
It's a Friday. Yeah. Ne?
But there'll still be a week left.
Yeah. So Mr. Colonel Ginanda doesn't have to come on the 9th
Yes.
because it's just a report to say I'm ready. We are ready for the 19th. Is that not so?
But shouldn't we perhaps make it the 16th of May? This now the Friday before the 19th, because a lot of ground can be covered in a week's time.
Yeah. Fine. Look, I'm
But
in
you're
your
in the
hands.
hands of Advocate Minister.
16th of May. Mr. Ramsivil, are you available on the 16th of May?
My lord, I think the initial proposal of the 5th of May
Yeah.
for the report back then on the 19th, we proceed, my lord. The 16th is closer to the 19th.
19th.
It doesn't serve any purpose.
So tell your colleague, Mr. Baloyi, they say,
We are in the hands of Advocate Minister. We just thought that, say for instance, we come back on the 5th and he says he still has got some ground to cover.
that's so. Oh, I see.
That leaves him with about a week, a week and a half. It's too soon. So I thought, if we postpone it closer to the 19th, he would have covered wherever he needs to cover, and he can then inform the court that I've covered whatever I need to cover, or I still need more time.
Mr. Nisi, what's your view?
The 5th of May, my lord.
5th of May.
5, yes.
Is it okay? Mr. Ramsivi, the 5th of May, is it okay? We all forget things, is that not so? I want to remind you of first one, it has got nothing to do with what you are saying. The other day I asked you, I said, even you, Mr. Ramosipidi, you cross-examined on an aspect which was not covered by the evidence which was being adduced. You remember the ballistic expert, Leroux, is that Leroux?
Yes,
Is that Leroux? Who's the guy who was the verifier?
It's Sereo.
Sereo, you remember? He said, I never cross-examined him. I remember you lecturing him about a book which has got principles. You remember that evidence?
Yes.
You came with that. I didn't know there was a book. And you read it for him to say, hey, this is what's happening, da. And you had to comment.
yes, but
Okay, fine.
exceptional.
Fine, okay, fine.
And I think Colonel Sereo did say he's familiar with the book that is referring to.
Yeah, quite. Yeah, I remember that. Sorry, Colonel. Apparently, it's going to postpone again. So, but you must come on the 16th, is it? No. 19th, sorry, the 19th.
Yes.
If you want to come on the... No. Just a joke. Okay.
Rank is Brigadier, my lord. It's Brigadier Gininda.
Oh, is that so?
Yeah,
I
he's a-
thought
he's a
colonel
big-
is higher, eh?
No, it's lower.
Oh, it's lower.
Yeah, so he's been demoted. He's a brigadier.
Yeah, I'm sorry about that. I thought you're above a brigadier. Okay. So these ranks, they are now certifiable, am I saying? Because these are military ranks.
Yes, they are, my lord.
So they have been certified by law.
Indeed, my lord, yes.
Okay, then we come back on the 19th again.
Phakameng?
Oh, that's
Yes, Phakameng, Bosoro.
you say?
The 5th.
The 5th, sorry, the 5th of May. Okay, thank you. Yeah.